Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. Today's Tuesday, 10 a.m. Pacific time here on the Bottled Business Sense show. Welcome back to all our regular viewers. And if you're new to the show, welcome to this episode. We look forward to providing you with some useful and valuable information here on today's topic. Before I bring on my co-host, Bill Bernard, he is going to speak on using deeds as an estate planning tool, which he has a lot of really good information on that. So why don't we just go ahead and jump into it and bring Bill onto the episode.
Hey, Rick. I've gotten so many questions about deeds. And generally, most people don't think, they'll say, well, how do I get my deed? How do I transfer my property into my trust? And that's pretty simple because I prepare a deed as part of my trust package for my clients, along with a preliminary ownership application or statement. And they go down to the courthouse and they file it. But there's still a lot of questions about deeds and whether or not there are different deeds, and also how can they be used in some form or fashion as a tool for estate planning. So let me start with the basics. I thought I'd just go right here to kindergarten, right? And just say a property deed is a legal document that can be used to transfer the ownership of property. We pretty much know that, right? For the deed to be valid, it must be signed by the person interested in transferring the real estate and include within it the names of both previous and current owners or the grantee and the grantor. So what I thought I'd do is talk a little bit about how deeds can be useful when dealing with inheritance issues and the transference of property upon one's death. There are many different types of deeds. So let's start with beneficiary deed. I don't know how many people have heard of this or are aware of it, but let's talk about a beneficiary deed right off the top. When a grantor, the person who creates a trust, passes away, a beneficiary deed, also known as a transfer on death deed, okay, TOD, typically initialized as, can be used to transfer the ownership of property. This is one of the most common types of deeds because it is not necessary to have the deceased's will probated before the transfer can occur. You have typically a living trust, you have a beneficiary. The beneficiary is named as a successor to the property. The beneficiary fills out a transfer on death deed, and then the property is transferred to that beneficiary. Now, there are some pros and cons to beneficiary deeds, and I thought it might be worthwhile to go through some of these. Beneficiary deeds are less expensive than other methods of transferring property. And now I'm going to throw a monkey wrench in here, right? Because if you have a beneficiary deed, you're essentially naming a beneficiary who can transfer that property by way of that deed, whether they have a will or a trust, okay? So typically, this is a type of deed that you devise to transfer property upon the death. It's sort of like an IRA, where you have an IRA and you have a beneficiary. Well, now you have a deed with a beneficiary who gets the property upon death, and you don't need a will or a trust to do that. I mentioned a living trust before because typically property is then transferred to the beneficiary after the trust, after the the trustee or the trustor passes away. But what happens if you don't have either? Well, you can use this TOD to transfer property to the person you want to transfer it to, and it allows for probate to be avoided. Okay. The problem I see right off the top is typically if you're going to have a trust in California, you certainly want to have a trust if your value of your assets are over $150,000, because if they're under 150 or 150 or under, you can do a small probate affidavit that allows you to wrap things up rather quickly. But if they're over 150,000, then you're going to need to do probate. And so while you may avoid probate, in most property, let's face it, folks, right? Most property is going to be over $150,000. So if you use the TOD to transfer property without a will or a trust, if you have other assets, now you're going to have them probated, right? So why not transfer the property along with your other assets by way of a living trust and avoid probate for everything, not just the property? Because the deed has the name of the individual whom the grantor assigns their survivorship rights, there is no need to go to probate, as I said, but again, your other assets may have to be probated. This significantly does ease the financial burden on the intended beneficiary of the asset. It allows the assets to be distributed much faster than if probate were necessary. And a huge advantage of beneficiary deeds is that the named beneficiary will have no interest in the property. This allows for a smooth transfer of property through a beneficiary, as well as you being exempt from any gift tax, because you're not gifting it. When you have a TOD, it's not considered a gift. Rather, it's a property transfer by way of a TOD, an estate planning tool that avoids probate and avoids any gift tax implications, because gift tax has to be a gift tax a return has to be filed if you gift somebody something over and above what the gift tax exemption is. So again, great, fantastic, avoids probate. But again, if you have other assets that will have to be probated because you didn't have a living trust, why not just put the property in question in a living trust and not bother with the TOD? That's something that you have to make a decision about. Another plus, however, to this TOD is that you can revoke or alter your named beneficiary at any point. And beneficiary deeds in and of themselves do come with some downsides, one of which I just mentioned. To me, it's a downside. If you have other assets and you have to have them probated, why not include the property in the trust and not use a TOD? But beneficiary disagreements may not be fully avoided since the asset didn't go into probate. Now, you have a TOD, you don't have a living trust. You don't need to go to probate. But if there's a dispute between beneficiaries regarding that property, it may not be fully avoided because you didn't go through probate. So there may be some other important aspect that ends up arising where some litigation ensues, and this may end up costing the litigants a substantial amount of money. Also, if you fail to maintain ownership, your credit liabilities are still responsible for your asset, as the beneficiary deed will not protect it. So you may become liable for any credit liabilities held by the original deed holder. Give you an example. For example, people often do not think to name a second beneficiary as a precaution in case the first one dies. If this were to happen, a revocation may need to be filed because assets will not be transferred to heirs. So you may have these problems where you have arguments between respective beneficiaries. You may have a credit issue that's not protected by way of a TOD. And then you may have a situation where because you didn't name an alternative beneficiary and the initial beneficiary is not around or passes away, then you will need to file a revocation because assets will not be transferred to an alternative beneficiary that's not named as an alternative beneficiary. So hopefully that trustee while he's still, that original deed holder while he's still alive, or he or she will be aware that the first name beneficiary passes and then name an alternate. What would be the best way to do it? Just name a first and a second and a third off the bat, right? So let's now jump to general warranty deeds and get away from the TOD, which is basically an estate planning tool, but has certain advantages and certain pitfalls, as I pointed out. A general warranty deed requires the grantor to make multiple covenants or legal commitments and warranties which state that the property is guaranteed to be protected. One, the grantor affirms that they legally own the property by way of a warranty deed. Two, the grantor affirms that the property does not have any unmentioned encumbrances or liens, and that the grantor, if the grantor does have defective title and is unaware of the defect to some extent, the possession of the property by the grantee must remain silent. In other words, the grantee's ownership remains silent. The grantor is going to have to be involved with any unknown, encumbrances or liens that then become known. Essentially, a warranty deed says I have no encumbrances and the property is mine and I own it when I transfer it to you. It guarantees you as the grantee for protection for any unknown things that may happen. So you're not affected by the sale of the property or the transfer of the property. That's generally what a general warranty deed is. How about a special warranty deed? Well, a special warranty deed offers the grantee less protection because within it, the grantor warrants that they have received their newfound title of ownership of the property and that none of their actions have caused a defect to it. This means only that faults that are warranted are the ones that have occurred in the duration of the grantor's ownership. There may be another defect that occurred before the grantor got the property and before the grantor then sends it on to you. So special warranty deeds are advantageous in the event of foreclosure sales because banks can only take warranty up to the point of repossession. That's important, but I'd rather not use a special warranty deed under these circumstances because you're only protected in terms of the ownership life of the grantor, whereas in a general warranty deed, there's a representation that there are no encumbrances or liens at all. How about a quitclaim deed? This is something I think people, Rick, that you typically always ask about. They're also known as non-warranty deeds and are often the least favorable because there's no guarantees made surrounding the quality of the title. No guarantees. They're often used if one is unsure whether defects are present or not, or if the grantor does not wish to be held accountable under the title of covenants. But that's his deal. You, as a grantee, would not want a quitclaim deed. So when would be when would it be beneficial to use a quitclaim deed? Well, if I own property and I'm transferring my property into a living trust, I pretty much can use a quitclaim deed, which is real simple and straightforward because I know it's going to be my property within that trust, and all I'm doing is transferring my name, taking that off and putting the name of the trust in, right? So why would there be any problems with encumbrances? Whatever is there is still going to be there for me versus still going to be there for the property when it's transferred in the name of the trust. So stay away from quitclaim deeds except under very certain circumstances that your lawyer recommends. Again, the general warranty deed is the best. And how about special purposes deeds? Let's talk about special purposes deeds as the final one. And this is when one passes away without a will, the assets of the deceased will be disposed of by an administrator appointed by the court. And the grantee will receive title to the property. That is the administrator's deed, which is called a special purposes deed, okay? What about another type of special purposes deed called an executor's deed? When one passes away with a will, their assets will be disposed of by the executor of the state before the grantee can receive the title of the real property. don't get too hung up on those two. If you don't have a will, or even if you do have a will, you're probably not in the best of circumstances anyway. Off the top, get a living trust. Avoid all the bull. Okay, I want to end the program by just referencing something about wills. We know that a will is a legal document desired to distribute one's estate after their death. If you die without a will, you go to probate. Things pass intestate succession by way of your heirs. The only thing a will does is name who specifically out of those heirs or friends you want to get your assets. You still got to go to probate. All assets go directly to named beneficiaries with a will, but it must be probated, and each asset must be assessed before your beneficiaries can claim a right to the inherited property. So what does all this mean? What does all this emphasis mean at the end of this show after we're talking about deeds? Why do we want to bring up and reference a will? Because if deeds are not right for you as a means to use as an estate planning tool, for example, we talked about TODs, transfer on death deeds, then you have two choices, a will or a living trust. And I point out these problems with a will because I'm hoping you decide again to go into a living trust. So we've done a full circle talking about deeds, wills, and now back to living trusts. If you want to do things the right way, get that living trust and dispose of all of your assets at one time without probate and the costs involved in probate. So I hope that kind of brings us full circle in a way and emphasizes the fact that I'm not really a big player with these deeds. These deeds play a role to a certain extent, especially if you have an estate that may be under $150,000 in terms of your other assets. Maybe you have a piece of property you want to do a transfer on death deed, TOD, fine. And then the rest of your assets are under $150,000. You do a small estate affidavit and you go through a very minimized short probate procedure. But if you have assets over $150,000 over and above your property, then why not put it all in a living trust and avoid all of the headaches and hassles that come along with probate. So I hope that makes things, answer some questions about deeds, what the distinctions on deeds are about. And I did this for two reasons, not only to emphasize the need of a trust, but also to strike a chord with anybody watching this as to the distinctions between deeds, because a lot of times you use deeds without even involving estate planning when you're transferring or selling property long before you pass away. So these deeds give you some point of reference in terms of what you want to use and when you want to use them.
Well, very good. Awesome episode there, Bill. And folks, if you have any questions or need further discussion about that, you can reach Bill at the contact information below this video. He always calls back or communicates with you on email, whichever one you choose. Go ahead and reach out to him because he's here as a resource. And I give you some initial guidance should you decide to retain him. So anyway, thanks again, Bill, for the valuable episode. And I know last week we spoke a little bit about some other issues on owning corporate stock, S Corp stock in living trusts, and we also ended that episode with one of the offerings that you have in your toolbox, and that's the Protect Your Estate 365 resources there. So folks, give that site a visit. There's a whole host of very specific information there. You know, Bill and I helped Bill produce some of the stuff that's on there, and I learned a lot just from watching him and watching the videos and putting that whole thing together. So go on to the website, PYE365.com or protectourestate365.com. Learn a little bit more about estate planning, and then feel free to reach out to Bill.
And think about the value while you're there. I mean, seriously, don't listen to me or anybody else. Think about the value. You have an attorney involved in doing a complete estate plan for you, all of the various different documents that go with it, not just the trust. $15.99 is the current price. There are multiple phone calls you go through with your attorney, meetings. There are follow-up revisions of drafts that somebody just really can't appreciate unless they're charged by the hour and understand what an attorney does to get all these things exactly the way you want it. And go out and go anywhere else and challenge anyone else to do all of that and be at your beck and call with as many phone calls and meetings and changes that you want, and see if you can get that kind of value. And if you can, I'd go for it. But that's why this site was devised, to help people who need this sort of protection and who can't go out and afford these high-priced law firms.
Yep.
So give it a shot, at least take a look at it, form your own opinions, and then go from there. Thanks, everybody, for watching. I appreciate it, and good health and best of everything in your business.
All right, folks, thanks for being here on this episode of the Bottled Business Sense Show. We'll see you again in a couple of weeks. Take care.